How do you prove police entrapment in court? Have you ever wondered how someone can claim they were tricked into committing a crime? This is where the concept of police entrapment comes into play. Understanding how to prove this in court can be crucial for a defendant's case. So, let's break it down into simple terms. To prove police entrapment, the defense must show that law enforcement officers or their agents were the ones who induced or persuaded the defendant to commit a crime. This means the idea to commit the crime did not come from the defendant. Instead, it originated with the police or their agents. Next, the defense must demonstrate that the police actively urged, pressured, or otherwise induced the defendant to commit the offense. This could involve tactics like threats, fraud, or harassment. Simply providing an opportunity to commit a crime does not count as entrapment. Another important point is that the defendant must show they were not predisposed to commit the crime before the police's involvement. This means they had no intention or willingness to break the law until the police stepped in. In legal terms, entrapment is considered an affirmative defense. This means the defendant admits to committing the crime but argues that it was due to government misconduct. The burden of proof lies with the defendant. They must establish entrapment by a preponderance or clear and convincing evidence, depending on the jurisdiction. When applying this in a criminal defense strategy, lawyers will carefully examine the actions of law enforcement during the investigation. They will look for evidence that police went beyond just offering a chance to commit a crime. If the police actively persuaded or coerced the defendant, especially if the defendant had no prior inclination to engage in criminal behavior, this could support an entrapment claim. If the defense is successful in proving entrapment, it can lead to an acquittal. The law aims to prevent convictions based on crimes that would not have happened without government inducement. However, if the defendant was already willing to commit the crime and the police only provided an opportunity, then entrapment is not a valid defense. In summary, to prove police entrapment, the defense must show that the idea and inducement came from law enforcement and that the defendant was not otherwise ready or willing to commit the crime. This defense serves to protect individuals from being unfairly trapped into criminal conduct by government agents.